Hello friends, I am Satish Ahuja, editor of legal books. Thank you friends for appreciating my earlier videos on different legal topics. Your support has been much more than I expected. It encourages me to make more videos on different legal topics. In this video, I will explain the law established by the Honorable Supreme Court of India about rights and responsibility of parents, senior citizens and their children or relatives under the Maintenance and Welfare of Parents and Senior Citizens Act 2007 and scope and extent of power of Maintenance Tribunal. I will also explain as to when Maintenance Tribunal can order children or relatives to pay a monthly allowance for the maintenance and expenses of senior citizens, and what happens if the children or relatives do not follow order of Maintenance Tribunal, and power of the tribunal to order eviction of children from the property owned by a senior citizen, and whether eviction is compulsory in every case or it depends upon the facts and circumstances of each case. Friends, under Article 141 of the Constitution of India, the law declared by the Supreme Court is binding on all courts across India. Also under Article 129, the Supreme Court is a court of record and has power to punish for contempt. Therefore, this judgment can be used as a strong authority in all relevant cases. Friends, if you find this information helpful, please like, share and subscribe to my channel. This legal point was explained by the Honorable Supreme Court of India in the case of Samtola Devi, Samtola space Devi, Samtola Devi versus State of Uttar Pradesh, Civil Appeal number 4442 of 2025, and judgment was delivered on 27 March 2025. In this case, Honorable Supreme Court of India held that Maintenance Tribunal under Senior Citizen Act 2007 can order eviction only if it is necessary to protect the senior citizen. Just because the parents own the property is not enough reason for eviction. Tribunal must record specific reasons for such an order. Senior Citizen Act 2007 mainly provides that a senior citizen or parent who cannot maintain himself from his own income or property can apply for maintenance against his children, not minors, grandchildren or other specified relatives. Tribunal may order a monthly allowance for maintenance and expenses. If children relatives do not follow this order, then Maintenance Tribunal can impose fines or even order imprisonment for up to 1 month or until payment is made. Senior Citizen Act 2007 itself does not specifically mention eviction from property. However, as per the Supreme Court judgment in S. Vanitha Vanitha versus Commissioner Bengaluru Urban District Tribunal, Urban District, Tribunal can also order eviction if it is necessary and expedient to protect senior citizen, but eviction is not mandatory in every case. This is a case where parents were in litigation with their sons and sons were in litigation with their parents. Relations of father Kallumal and his wife Samtola Devi were not cordial with their sons. Consequently, in 2014, father made an application to the SDM alleging that his eldest son, Krishan Kumar, often beats him and tortures him mentally and physically. He has friendship with people having criminal antecedents and he often abuses him. His behavior resultantly deteriorated his position in the society. Therefore, requesting SDM to take appropriate action against him in accordance with law. Thereafter, in 2017, Father Kallumal, along with his wife Samtola Devi, initiated proceeding for grant of maintenance against their two sons. And family court awarded maintenance of rupees 2,000 to father and his wife each. Total rupees 8,000 per month payable equally by two sons. Further, in 2019, Kallumal and his wife initiated proceeding under the Maintenance and Welfare of Parents and Senior Citizens Act 2007 before the Maintenance Tribunal, alleging that his house in question is his self-acquired property which has shops in the lower part. In one of the shops, he was operating his utensil business since 1971 till 2010, and that, taking advantage of his illness, the business of his shop was taken over by his eldest son, Krishan Kumar, who later started pressurizing him to sell out the house. He further alleged that Krishan Kumar was not looking after his daily needs, not even his medical expenditure, rather was torturing him mentally and physically. Therefore, he requested tribunal to evict him from the house so that he could make his own arrangement for peaceful living. The tribunal, upon consideration of the entire evidence on record and noting the submission of the parties, directed Krishan Kumar not to encroach upon any part of the house without the permission of his parents, except the shop in which he is carrying utensil business and the room with a bathroom occupied by him in which he resides with his wife and children. It was also provided that if he humiliates his parents, then eviction proceeding would be initiated against him. Two sons were directed to continue to maintenance to the parents, as directed by the family court. In charge of the concerned police station was also directed to visit the house of Kallumal either himself or through regional sub-inspector every 10 days, so as to inquire if they are living peacefully and that no humiliation or harassment is caused to the parents by son Krishan Kumar. Father and his wife, Father Kallumal and his wife, were not satisfied by the above decision, and as such they preferred appeal before the Appellate Tribunal District Magistrate. The Appellate Tribunal set aside the order passed by the SDM and directed for eviction of son Krishan Kumar. However, High Court in writ petition, by setting aside the order of eviction passed against Krishan Kumar, but maintained the other direction given by the tribunal. During the pendency of the above proceeding, Kallumal died. Thus, Samtola Devi filed appeal before Supreme Court seeking eviction of her son Krishan Kumar from the house in question. Appellate Tribunal did not give any reason why eviction of son was necessary for the protection of the senior citizen. It wrongly ordered eviction only because the property belonged to the father, ignoring the fact that son's claim to a 1/6 share and related disputes are pending in civil court. Honorable Supreme Court of India held that instead of eviction order, tribunal could have ordered Maintenance under section 4 and 5 of Maintenance and Welfare of Parents and Senior Citizen Act 2007, and restrained son from harassing his parents, and that High Court was right in cancelling the eviction order while keeping the other direction of tribunal intact. Friends, if you like to understand this point more deeply, you can read the full Supreme Court judgment. Once again, the name of the case is Samtola Devi, Samtola space Devi Devi versus State of Uttar Pradesh, Civil Appeal number 4442 of 2025, and judgment was delivered on 27th March 2025. Thank you, friends. I will try to bring you another video soon on another important legal topic. Till then, goodbye and take care.